Welcome to another deep dive. You know, we always talk about diving into history books and memoirs and all sorts of things. But today we're going full Law and Order on you.
Yeah, we're putting on our thinking caps and our robes because today we're tackling a Supreme Court case.
That's right. We're taking on the role of talk testimonies.
Your one-stop shop for all things SCOTUS.
Precisely. And the case we're breaking down today is Biestek v. Berryhill.
A real head-scratcher, let me tell you.
Oh, absolutely. But before we get into the weeds, let's make sure everyone's on the same page. What was the end result of this whole legal showdown?
Well, the Supreme Court ultimately sided with Mr. Biestek, the guy who brought the case. They reversed what the Sixth Circuit Court of Appeals had decided.
Okay, so a win for Biestek. But what exactly did the Supreme Court decide? What was that key takeaway?
The majority of the justices said that if a vocational expert won't show you the data they're using to back up their opinion, well, that testimony might not be what they call substantial evidence.
Substantial evidence. That's a term we hear a lot in legal contexts. What does it actually mean when we're talking about court cases?
It's the litmus test, the standard. It's what courts use to review decisions made by administrative agencies, like, say, the Social Security Administration.
So in this case, it was all about whether the expert's testimony was solid enough to hold up under scrutiny, right?
Right, because it was a Social Security disability benefits case.
Okay, so let's get into the heart of the matter. What was the fundamental legal question that the Supreme Court was wrestling with here?
Basically, it boiled down to this. Can a vocational expert's say-so about how many jobs someone with certain limitations can do? Can that be substantial evidence, even if they refuse to show the data backing it up?
And that's a pretty crucial question, especially for someone relying on disability benefits.
Yeah, the stakes are high in these cases. So the guy who appealed to the Supreme Court, Mr. Biestek, he had a lawyer named Mr. Baba arguing on his behalf.
Right. And what was the main thrust of Mr. Baba's argument?
Well, he argued that when a vocational expert throws out specific numbers about job availability, those numbers have to be based on real, hard data. And if they refuse to share that data when asked, their testimony just doesn't cut it as substantial evidence.
Because without the data, you're basically taking their word for it.
Exactly. And he said this isn't just about being fair, it's about the very definition of substantial evidence in administrative law.
So it's about the bedrock of how these agencies make decisions, how they're held accountable.
Precisely. He also made a point about cross-examination, the back and forth questioning in court.
Right, that's a cornerstone of our legal system.
He argued that you can't properly grill an expert who's dealing with specific statistical figures if you don't have the raw data to work with.
Kind of like trying to solve a math problem without knowing the formula.
It just doesn't add up. He kept hammering on this idea. If you can't verify those statistical claims, they can't be considered solid evidence in these administrative law cases, especially when you're asking for the data and they're still holding back.
Makes sense. Any other key points that Mr. Baba emphasized?
Oh, yeah. He brought up this idea that if an expert says they have a source but refuses to name it or show it, that itself throws shade on the whole process, creates doubt.
Almost like they're hiding something, right?
Right. And in this specific case, the vocational expert said she couldn't share the data because it was all confidential client files.
Privacy concerns. Understandable.
Sure. But here's the kicker. Even the government's lawyer didn't try to defend that confidentiality claim in front of the Supreme Court.
Really? So even they weren't totally convinced by that excuse?
Nope. And Baba suggested, hey, you can just redact client names to protect privacy. It's not rocket science.
Seems like a simple enough solution. But I'm sensing there's more to this skepticism about vocational experts, isn't there?
Oh, yeah. There's been a lot of criticism about how they come up with these job numbers. Some people think they're inflating them, even making them up.
Wow. So not exactly a spotless track record then.
No. And to drive the point home, Ba gave a pretty stark example. Imagine two vocational experts looking at the same job, like, say, nut sorter.
Okay, nut sorter, got it.
Well, these two experts could give wildly different numbers for how many of those jobs are actually out there.
Yikes. That's a pretty big discrepancy.
Huge. And Baba clarified that he wasn't saying experts have to hand over all their materials all the time, just when they're asked for them in court.
So targeted transparency, not just a data dump.
Exactly. And he pointed out that the Seventh Circuit Court of Appeals already had a rule about this.
Oh, really? What did that rule say?
Basically, if an expert is using private statistical sources and they refuse to share them when asked, their word alone isn't enough to be substantial evidence.
So Biestek's lawyer was basically saying, hey, the Seventh Circuit gets it. Why doesn't everyone else?
Right. Now, on the other side, you had the government's lawyer, Mr. Yang.
Okay, let's hear what he had to say. What was the government's defense strategy?
Well, Yang's main point was that Congress gave the Social Security Administration a lot of power to decide how to build the evidence record in these disability cases. He basically said, hey, the SSA knows what it's doing.
So trust the process, essentially.
Right. And he pointed to the SSA's Vocational Expert Handbook, which tells experts to cite their sources, explain them, and be ready to hand them over. But he said this is talking about general vocational resources, not some random person's client files.
Okay, so public information versus private data. Makes sense.
Yeah. And he explained how these vocational experts usually work. They look at something called the Dictionary of Occupational Titles to figure out which jobs are relevant.
Sounds official.
Very official. And then they use public data from places like the Bureau of Labor Statistics, the BLS.
Yeah, I've heard of that.
And they use their professional know-how to figure out how that data applies to the person applying for disability. So the government's argument was that they have procedures in place, and those procedures are reasonable. They also pointed out the importance of cross-examination as a way to test the expert's claims. It wasn't like the lawyer wasn't able to ask questions.
Okay, so they're saying cross-examination should have been enough to get to the bottom of things.
Exactly. And Yang said that in this particular case, there wasn't enough digging into the specific job numbers the expert gave.
So maybe Biestek's lawyer missed an opportunity there.
Maybe. He also brought up a logistical issue. It's just not practical for experts to drag all their client files to every single hearing.
Fair enough. Sounds like a paperwork nightmare.
Oh, yeah. And he reminded everyone that the judge in Biestek's hearing had already said those files didn't have to be shared. So he's saying, why should the expert be penalized for following the judge's orders?
Okay, so following the rules. And he kept emphasizing that substantial evidence means looking at the entire record, not just picking apart one piece of testimony.
Right. He's saying, take a step back and look at the bigger picture.
Makes sense. What about the whole question of what's considered a significant number of jobs?
Ah, yes. That was a key point of disagreement. The government pointed out that the Sixth Circuit, the court that had ruled against Biestek before, had previously said that roughly 6,000 jobs nationwide could be considered significant.
Okay, so that's their benchmark.
Right. And in Biestek's case, the expert had said there were like 360,000 jobs available. Way more.
Wow. Yeah, that's a lot.
So the government's argument was, look, the number's huge. Does it really matter if it's not exact?
Like, what's a few thousand jobs between friends, right?
Exactly. And they also threw out this idea that maybe different experts come up with different numbers because they're answering slightly different questions or using different definitions for the jobs.
Ah, so the devil's in the details.
Right. Plus, they pointed out that Biestek's own vocational expert didn't even argue with the job numbers the other expert gave.
Interesting. So the government was really pushing back against this idea of a hard and fast rule. They're saying, we have a system, and it's based on good old-fashioned cross-examination.
Precisely. They believe in the power of good questioning to bring out the truth. And Yang highlighted that the expert in this case did use public data from the BLS, both nationwide and for the specific region.
Okay, so she wasn't just pulling numbers out of thin air.
No. Plus, she had done her own surveys of the local job market. Yang explained that these surveys help the expert understand what specific limitations might prevent someone from doing certain jobs, even if those jobs technically exist.
So getting a more nuanced picture of the situation.
Exactly. And he said that what Biestek's lawyer was asking for was basically a give me everything rule, which he argued wasn't how substantial evidence works.
So no fishing expeditions.
Right. And he claimed that the Seventh Circuit, even with its rule, didn't always apply it consistently.
So not exactly a slam dunk argument there either.
No. And finally, he warned that if they made it a requirement to hand over all these personal client files, it would just bog down the whole system and create massive delays.
Okay, so a logistical nightmare again. So that was the government's case. What did Mr. Babha have to say in response?
Well, he went right back to that vocational expert handbook we talked about.
The SSA's rule book.
Right. He emphasized that it says experts have to be ready to cite, explain, and provide any source they use, not just public ones.
Ah, so he's saying the government's own rules contradict their argument.
Exactly. And he basically said, look, if you're so worried about administrative burdens, maybe you should rethink your own policies.
A bit of a mic drop moment there.
Yeah. He also pushed back on how the government was characterizing the Seventh Circuit's rule, saying that when someone asks for data and doesn't get it, they often keep the record open so the data can be submitted later.
So it's not an all-or-nothing situation.
Right. And he kept hammering on this point. If an expert gives specific job numbers and says they got those numbers from a survey, there has to be some data backing it up, especially if they're asked for it.
So it's not enough to just say, I did a survey, and leave it at that.
Exactly. And he reiterated that all they were asking for was the same rule the Seventh Circuit already had. If an expert points to specific data sources and then refuses to show them when asked, their word alone isn't good enough.
Okay, so bringing it back full circle. Now, throughout all of this back and forth, the justices themselves were pretty active, weren't they?
Oh, yeah. They were peppering both sides with questions, trying to get to the heart of the matter.
What were some of the big concerns they had?
Well, Justice Alito, he was curious about why the strength of the evidence would depend on whether someone actually asked for the data.
Like, shouldn't the evidence be good or bad regardless?
Exactly. He also wondered if this rule should only apply to vocational experts in Social Security cases, or if it should be a broader legal principle.
Interesting question. Expanding the scope?
Yeah. Then you had Justice Breyer, who wasn't too keen on creating a super rigid rule that would force experts to hand over all their data in every case.
It does seem a bit extreme.
Right. He brought up how in regular trials, experts use all sorts of information without having to produce every single source.
Makes sense.
So he was suggesting that maybe a case where there was really thorough cross-examination would be a better way to figure out the boundaries here.
Okay, so testing the limits of the system. And Justice Kagan had some really pointed questions about how the whole process was supposed to work without access to the underlying data. She's trying to understand how, if the expert is relying on some secret information to reach their conclusion, anyone can be sure that the process is actually fair. Like, if you can't see the expert's work, how can you be sure that the expert isn't just making things up? Her line of questioning really highlighted this tension between protecting someone's right to a fair hearing and respecting the idea that some information might be legitimately confidential.
Absolutely. Now, a few of the justices seemed particularly interested in the SSA's own guidelines and how they handled this whole issue.
Right, getting into the nitty-gritty of the agency's procedures.
Exactly. Justice Sotomayor zeroed in on that updated handbook that says experts should be ready to share their sources. She was basically asking, shouldn't we just follow what the agency itself says is important?
Deferring to the experts, so to speak.
Right. And she was worried that if these job numbers aren't backed up by solid data, they could be completely made up.
Yikes. That would undermine the whole system.
Totally. And she even brought up how Biestek's lawyer had initially been hesitant to acknowledge that the expert was actually qualified.
Oh, added a little wrinkle to the story there.
Sure. Justice Kagan, she kept poking at this idea of demanding the data on the spot. She was asking if the evidence should be judged as good or bad, regardless of whether someone asks for the source.
So focusing on the inherent quality of the evidence itself.
Right. But she also brought up the practical problem. How can a lawyer cross-examine an expert or a judge, double-check their conclusions if they don't have the underlying data?
It's like trying to judge a recipe without tasting the food.
Exactly. And she even asked if that handbook rule about providing sources was actually a hard rule or just a suggestion.
Okay, so questioning the force of those guidelines. Now, Justice Gorsuch, he took a different tack, didn't he?
Yeah, he compared it to how things work in federal court. He basically said if an expert in federal court refuses to show their secret data, the verdict would likely be overturned.
Wow, so drawing a pretty clear parallel there.
Right. And he acknowledged that everyone seemed to agree that if an expert hides crucial information, it weakens their whole argument.
So transparency is key.
Absolutely.
Yeah.
Chief Justice Roberts, he was more concerned about the practical side of things, asking if these new handbook rules would just slow everything down.
A valid concern for sure.
Yeah. Justice Ginsburg, she just wanted to make sure everyone was clear that Biestek's lawyer was asking for the same rule that the Seventh Circuit already had.
Keeping everyone on track.
Right. And Justice Kavanaugh, he asked if the Social Security Administration was already applying the Seventh Circuit's rule voluntarily.
So, checking if they were already doing what Biestek was asking for. Now, it's time for our favorite segment, the 10th chair.
Ah, yes. Where we get to play Supreme Court Justice for a day.
Exactly. So if you were sitting on the bench for Biestek v. Berryhill, what would have stood out to you?
Well, I think the biggest takeaway for me is that expert testimony has to be transparent, especially when it's the deciding factor in whether someone gets essential benefits.
So no hiding behind fancy titles or jargon.
Right. And while I understand the government's concerns about protecting client information, there are ways to do that without keeping everything completely secret.
Like redacting names, as Bubba suggested.
Exactly. And with all the criticism about how these vocational experts come up with their numbers, there needs to be a way to make sure they're not just making things up.
So checks and balances are crucial.
Absolutely. And I think the Seventh Circuit's approach, you have to show your data if you're asked, strikes a good balance.
Not too burdensome, but still ensures accountability.
Right. So if I were voting, I'd probably side with Biestek and say that hiding data when it's requested undermines the whole idea of substantial evidence.
A vote for transparency.
Exactly.
Well, there you have it, folks. That was our deep dive into Biestek v. Berryhill. We unpacked the arguments, explored the justice's concerns, and even put on our imaginary robes for a 10th chair deliberation.
We hope you enjoyed our little foray into the world of SCOTUS.
What are your thoughts on this case? Does the need for transparency outweigh concerns about privacy and efficiency? It's a complex issue with no easy answers.
We'd love to hear your perspective.
And make sure to join us next time for another deep dive into a new and fascinating topic. Until then, keep those brains buzzing.